So good morning, everyone, and welcome to this latest Fox Williams webinar on UK consumer law enforcement and EU tax reforms. We're joined today by Damon Wright, who's a director at Evelyn Partners and a tax specialist who will take, obviously, the second part of this talk on EU tax reforms. Now, we're going to aim to run today for about 45 minutes to leave some time for questions at the end. And if you would like to ask any questions, there is a Q&A box which you can click on to write in and post your question. We'll accumulate those and we'll try and pick those questions up at the end. This webinar is being recorded and we will circulate a copy of the recording and the slides after this session. And finally, just to make you aware, don't worry, we can't see or hear you because we've muted all microphones and we're not playing the video, so you don't need to worry about that. So with those introductory points complete, can I have the next slide, please? Next slide again. So the first session today, which is my session, is going to be around changes to the enforcement regime of UK consumer law. Now, these are going to be probably some of the most significant changes in the enforcement regime that we've had in the UK, and something that the CEO of the CMA recently said, and I'll quote here, was to be a watershed moment in the way we protect consumers in the UK. So we really are looking at significant reform here. And when I talk about consumer law, what I'm referring to, and I'll come on to it in a bit more detail, are those aspects of the consumer law regime in the UK which might be of general application, like the Consumer Rights Act or the Consumer Protection from Unfair Trading regs, but also some travel-specific regulation in the form of the package travel regulations. Now, generally in the UK, particularly in the travel sector, I think the regulators have perceived the compliance levels across the industry with this consumer law to be relatively poor, and that's primarily because of the rather weak, cumbersome, slow enforcement tools that the regulators have at their disposal. So what the government's looking at doing is to significantly strengthen the enforcement of consumer law in the UK and to put it on the same level as the enforcement of other consumer-focused laws, such as the GDPR, where we're all well aware of the turnover-based fines that we have for non-compliance with GDPR, where it's generally perceived that the compliance levels are much higher. And similarly, obviously, competition law is seen to be something which is quite rigorously enforced and where compliance levels are much higher than in sort of general consumer protection law, which I'll be talking about today. So, as I said, what the government's looking to do is to increase compliance levels with the existing law, and it's looking to do that mainly by doing two things. Firstly, the introduction of a summary enforcement procedure to make enforcement much quicker, and then also then to introduce eye-watering fines so that we see the sorts of fines as we've seen for non-compliance with GDPR and competition law. Next slide, please. So, having consulted about these reforms over the last couple of years, the government's introduced the new Digital Markets, Competition and Consumer Bill, and that was published on the 25th of April of this year. And you can break the bill is almost 400 pages, but you can break it down into different chunks. There's the first part which deals with digital market reforms. So this is really targeting and controlling the behavior of big tech firms such as Google and Facebook, whose practices are seen as being uh, anti-competitive or um, stifling innovation. So the government's looking at introducing new laws to control that aspect of the market. Secondly, there are going to be some reforms to the existing competition law regime in the UK, and that's really to do with enforcement. Thirdly, we have consumer law and reforms. So this is actually introducing new consumer laws, tackling particular issues such as subscription contracts, um, consumer saving schemes, and this has particularly come about because of the failure of some Christmas saving clubs and people like that. So query whether this may capture anyone who does have holiday saving schemes. So we're having sort of new laws which specifically target those issues. And then the last section, and the section that I'm going to focus on today, are changes to the enforcement of consumer law in the UK. Now, the bill is currently working its way through Parliament. It's at the committee stage at the moment, where it's going through sort of line by line scrutiny. So there is still some way to go before this will um, come into force, and obviously it's possible that there may be some changes to the bill before it actually becomes law. But it does seem to me, at any rate, reading some of the parliamentary debate and the debate in the committee, that there is cross-party support for this bill. So it certainly seems that it's going to be something which does come into force. Next slide. So, as I said, the bill looks at sharpening up enforcement of existing consumer law. And by consumer law, a whole bunch of it is listed in the Act. And I'm just picking out here the aspects of consumer law, which I think are probably the most important and the most relevant for travel companies, and which these new enforcement powers will apply to. So we have the Consumer Rights Act, which everyone will be familiar with. You know, this sets out obligations on traders to provide their services to consumers with reasonable skill and care. The Consumer Rights Act also imposes obligations on traders to ensure that their customer terms and conditions are fair. So unfair terms can't be enforced. We've then got the Consumer Protection from Unfair Trading regulations, which targets things like marketing practices, sales techniques, and is really focused on traders treating customers fairly. So sets out a bunch of fair trading obligations on travel companies. We've then got the consumer contracts regulations, which sets out some obligations on travel companies to provide information to customers before they book. There's also a right to cancel set out in the consumer contracts regulations, although generally that's not applicable to package holiday sales. So we don't need to worry about that so much. And then we have the package travel regulations, which obviously governs the sales of package holidays and linked travel arrangements in the UK. So when I'm talking today about the enforcement of consumer law, it's about the enforcement of these particular laws that I'm talking about. Next slide, please. Just to illustrate the sorts of things that that body of law is looking to target. So the Consumer Protection from Unfair Trading regulations targets things like marketing and sales techniques, and examples of current hot topics are some of the ones I've got on slide now. So the CMA is actually running a campaign about this at the moment. It's called the Online Rip-Off campaign, and it's really looking at what the CMA perceives to be unfair and dishonest sales practices online, which are bad for consumers. And it's published an open letter to traders setting out the sorts of things that it doesn't like. And many of these, which we see obviously in the travel industry, such as creating a sense of urgency, a false sense of urgency, as we have here. There's a deal which is being presented, which is time limited. We have a countdown timer on the right hand side of the screen, and this is something that we do see in the travel industry, and it's creating that sense of urgency to try to pressure customers into booking, which, if it's not true that the deal does end when the timer ends, then that's a problem because it's misleading. So that's one example. Next slide, please. Similar sort of thing. The first slide was talking about a particular deal. This second slide is looking at time limits to actually complete a transaction. And again, it's putting pressure on customers through the imposition of a time limit or a countdown timer to complete a transaction, and giving the sense that perhaps the particular deal that the customer is looking at won't be available at the end of the timer, so that they need to book now to secure that particular deal. Next slide, please. And again, similar sort of thing. We don't have a countdown timer here, but what we do have are claims that other people are looking at this same deal and they're going to buy it unless the customer buys it quickly. So again, pressure sales techniques, putting pressure on customers to make a quick decision and book so that they don't lose out. And again, you know, if these claims can't be substantiated, then that's obviously a problem. Next slide, please. Another common area that we see in the travel industry and generally online is where there's a discount claim being made. So there's a claim here on screen that a particular product was £120 and is now £90. So that's obviously conveying a message that the usual selling price of this product was £120, but there is a special deal available if the customer books it now of £90. And again, in circumstances where this can't be justified because it's not true, then that's a problem. And often it would be the sort of situation where, in fact, the product or the particular holiday wasn't on offer, on sale at a usual selling price of £120. Therefore, if that was the case, then this would be a false discount claim. And there are, you know, rules around that, where there can be circumstances where perhaps the price was momentarily spiked to 120 before it was then discounted to 90. These sorts of issues cause problems because they create a false sense of this being a good deal for the customer, whereas in fact it may be misleading. And next slides, please. And another example, it isn't part of the CMA's campaign, but another example of something I saw quite recently, which is in the news and which is currently a hot topic. So Rishi Sunak was in the news very recently, calling out this practice of drip selling, or drip pricing, it's sometimes known. And we can see that the Times picked up on this story and specifically called out airlines, hotels, and online booking sites which can participate in this practice. And it's essentially the practice where the customer may see a headline price at the very beginning of the booking journey, or perhaps in an advertisement, let's say £1,000 for a holiday, but then by the time that they come to book, in fact, additional fees have been added. In many circumstances, those fees may be unavoidable. For instance, it's a booking fee. So in fact, the customer ends up paying more by the time they get to paying at the very end. So the problem here is that the customer's kind of drawn in with that attractive price at the very beginning, but they end up through the selections that they inevitably make, during the booking journey paying more than that. So the Prime Minister's asked Bayes to look at this and to report back to him on what can be done. So this is another sort of hot topic that we have at the moment in the travel sector. Next slide, please. And just looking at finally some other examples of this consumer law being enforced in the UK. I mean, back in 2019, the CMA carried out a big review of hotel booking websites and some of the very large hotel booking websites, and looked at their sales and marketing techniques, picking up on some of the issues that I've just been talking about, as well as some others, and ultimately settling that those various enforcement claims through accepting undertakings from the hotel booking websites. And then obviously the other more recent example we've had is during the pandemic, where the CMA took enforcement action against, I think it's about 5 or 6 different travel companies over their failure to pay refunds to the customers within 14 days, as is the requirement under the package travel regulations where package holidays are cancelled. So most of those were settled through undertakings from the holiday companies, but then one of which, Teletext Holidays, ended up being taken to court because it ended up, well, effectively running out of money because it gave undertakings and then couldn't comply with those undertakings. So the CMA eventually took them to court to enforce those undertakings. Next slide, please. Now, as you may have picked up as I've gone through those recent examples, the regulators tend to use, I mean, the regulators have different enforcement tools in their toolbox at the moment. They have criminal enforcement powers, which apply to some breaches of consumer protection law. For instance, breaching some aspects of the package travel regulations is a criminal offence. But the reality is that the regulators very, very rarely use those criminal enforcement powers in the UK. And in my experience, it tends to be reserved for what I would call to be sort of truly fraudulent behaviour. And that would be sort of a situation where somebody sets up a travel company in order to collect in a load of customer money and then they disappear. So we tend not to see the criminal enforcement powers being used in the sorts of examples that I've just been talking about. The powers that the regulator typically uses are the civil enforcement powers that they have. And what this entails is basically the regulator starting a civil claim or threatening to start a civil claim in the High Court, where they ultimately seek an enforcement order. It's a bit like an injunction. It's just basically a court order to force the company to do something or not to do something in order to comply with consumer law. And taking COVID refunds as an example, that would be an order which requires the travel company to pay refunds to customers within 14 days, for instance. So these civil enforcement powers that the regulators can use also allow them to seek what's known as consumer redress measures. So these are so the first aspect of the enforcement order is usually an order that the travel company, stop breaching consumer protection law or comply with consumer protection law. And that's almost like a look. That's sort of looking forwards. These consumer redress measures allow the regulators to actually force the company to provide redress to those consumers that may not have had their rights. So in the example of COVID refunds, this would have allowed the regulators to basically get a court order to force the travel company to pay those customers back that maybe didn't get their refunds, or perhaps were forced to accept a voucher without an offer of a refund. So that it's basically a bunch of rules which allow the regulator to um, make the travel company make good the consumer. Um, Now, as I've mentioned, these enforcement powers and these civil claims are often settled by way of undertaking. So what usually happens is that the regulator will start an investigation, and then before going to court, at some point in that process, there's an opportunity to negotiate undertakings with the regulator. What that means is the travel company giving um, promises to the regulator to do something or not to do something, um, which is of a similar nature to what the regulator would ultimately get if they went to court. So that would be a promise to refund customers within 14 days. It may be a promise to contact customers that weren't offered refunds in the past um, to pay those refunds. So it's basically an informal way of settling the regulator's enforcement activity and avoid having to go to court. Um, Now, one thing that the regulator doesn't currently have is any powers to impose fines. And we've obviously seen in other sorts of consumer enforcement action, GDPR being, you know, probably the most relevant example of the regulator, in that case, the ICO, being able to fine companies for breaching consumer protection law. At the moment, the regulator in relation to this consumer law that I'm talking about at the moment doesn't have those powers. So that's seen as being a bit of an omission from the enforcement toolbox. And just to mention as well, I mean, I've been talking about action that the regulator can take. There are also consumer remedies that the consumer can take advantage of, whether that's through claims in the county courts, perhaps as some form of collective claim in the High Court, but those are personal remedies that the consumer has. They're not remedies that the regulator can enforce. Next slide, please. So that's the current position. So what's changing? Well, probably the most significant aspect of this new bill are the direct enforcement powers that are being given to the CMA. And what this basically means is that the CMA will be able to decide for itself whether there has been a breach of consumer law. And then it will also be able to decide what the sanctions should be. And then it'll be able to impose those sanctions on the travel company. So this will all be done outside of the court process. They won't need to go to court, as they do at the moment, to get a judge to decide whether there has been a breach of consumer law and to impose remedies following that breach. That's all being taken out of the courts, being put in the hands of the CMA, which will be able to decide all of this for itself. So it's going to significantly speed up the enforcement regime, whereas at the moment, going to court obviously takes a long time. You've got to instruct barristers. There's an opportunity to file a claim, a defense to that. In some circumstances, they may need to be disclosure. So it's quite a long process. And then you've got to find time in the court list, which at the moment the courts are very busy. So it can actually take quite a long time to get cases on. And this has been a common complaint for the regulator because it means that was perceived to mean that some travel companies can, sorry, not travel companies, some companies can game the system by perhaps dragging out the process, getting involved in procedural skirmishes, which actually just soaks up resources at the CMA and can just drag the whole thing out. So that's obviously that issue is just going to be resolved by giving the CMA the power to decide what should be done when there's been a breach of consumer law. And the other headline grabbing aspect of this new regime is that the CMA will be able to impose fines of up to either 10% of the group level turnover of the relevant travel company, or £300,000, whichever is the higher amount. So I'll come on and talk to you in a moment on how this group level turnover is to be calculated. But as you can see, it's potentially very significant if you're looking at turnover based fines for non-compliance and for doing the sorts of things that I've described on the earlier slides. So it really is going to kind of ratchet up. Well, it's seeking to ratchet up compliance levels with the sort of consumer law that I've been talking about today. Now, there will be an appeal mechanism for the travel company, but the onus will be on the travel company to pursue appeals if it doesn't like what the CMA has decided, and ultimately it's going to be up to the travel company to appeal to the High Court against the decision of the CMA. Next slide, please. So I mentioned the turnover-based fines on the previous slides. There is some guidance in the bill at the moment about how this turnover is going to be calculated. And I've just got a bit of a worked example here to illustrate how that's going to work in practice. So if we assume that the infringing company here is the holiday company, so let's say the holiday company is not complying with the package travel regulations, and let's say that the holiday company has a turnover of 10 million, which is spread 3 million in the UK, 7 million in the rest of the world. And let's say the holiday company has a subsidiary which turns over 10 million, also has a parent company which turns over 20 million. Now the fine, the turnover is to be calculated by aggregating all of that together. So if you look at the holiday company, the turnover calculation will include UK turnover and rest of the world's turnover. And then if you look at sort of parents and subsidiaries, the turnover for the purposes of the fine will also include the turnover of any companies which are controlled by the holiday company and any companies which control the holiday company. So on that basis, and on the basis of this example, that could mean a potential fine of anywhere up to 10% of 40 million. So as you can see, very, very significant indeed. Next slide, please. Now, in terms of the relevant process and how this is going to work in practice, I'll whiz through this relatively quickly. But it all basically starts with the CMA commencing an investigation. And usually that starts with the CMA sending an information request to the travel company, setting out the information that they need to determine whether there's been a breach of consumer law or not. And at that stage, the CMA may, and I would say inevitably do, publicize the fact of the investigation. So in all of those investigations I referred to earlier, during the pandemic into the travel companies, the CMA publicized all of those investigations on the website, which then inevitably is picked up by the mainstream news media. Having received in the information and reviewed that, the CMA will then impose what's known as a provisional enforcement notice. And this will basically be a document which sets out the CMA's investigation, the CMA's findings, whether they believe there's been a breach of consumer protection law. If so, what breaches have occurred, what's the offending conduct, and then they'll go on to set out the remedial action that they want the travel company to take. And then if they're considering imposing a fine, the provisional enforcement notice will have details of the fine. And we then, once that's sent to the travel company will have an opportunity to make submissions in response, which the CMA will then take into account before serving the final infringement notice. And that will pick up on the same categories of information set out in the provisional enforcement notice, but it will now take into account any submissions from the travel company, and it'll be the final settled view of the CMA. There may be a publicity requirement at that stage as well. The CMA can require the travel company to publicize the final infringement notice. Perhaps that would be on its website, could even be in communications to affected customers. But that can obviously generate adverse publicity, and then it'll ultimately be up to the travel company to decide whether to accept that or whether to appeal it, or to appeal an aspect of it to the High Court within 60 days. Next slide, please. Now, running slightly short of time, so I'm just going to whiz through these next slides quite quickly. But just on the issue of undertakings, as is currently the case, the CMA will be able to accept undertakings from the travel company, although it doesn't have to. But it can decide whether it wants to accept or reject undertakings offered by the travel company. And if it does decide to accept the undertakings, then that will obviously be the end of the matter, provided that those undertakings are complied with. If those undertakings aren't complied with, then the CMA will have the power to enforce those undertakings by serving what's known as an undertakings enforcement notice. And that will just basically be a notice which requires the travel company to comply with the undertakings that they've given. And the CMA will also have new powers that they don't currently have to impose fines for any breaches of undertakings, which I'll just discuss briefly on the next slides, please. So I've mentioned already new powers for the CMA to impose fines for non-compliance with consumer law. The CMA will also have other powers to impose fines, and I've just listed them here. So one of which is, if after having gone through the enforcement procedure that I've just described, the CMA might make a final infringement notice, and then the travel company doesn't comply with that, then it'll be able to impose a fine. In addition to the fine for not complying with consumer law, it'll be able to impose a separate fine for not complying with the final infringement notice. And I think the maximum fine here is 5% of the group turnover, or 5% of daily group turnover, or both, if they're feeling like being particularly draconian on the travel company. And there are similar powers to impose fines if the travel company gives undertakings and then doesn't comply with them, or gives undertakings, doesn't comply with them. The CMA serves an undertakings enforcement notice and then doesn't comply with that. So you can see that there are lots of different circumstances in which the CMA can force compliance through the imposition of fines. Next slide, please. And just very quickly on this and the next slide, at the outset of the investigation, as I've said, the CMA will usually ask for information from the travel company to allow them to determine whether there's been a breach of consumer protection law. So if travel companies give false or misleading information to the CMA, then the CMA will be able to impose a fine for that reason. Can you skip forward 2 slides, please, Eva? So before I hand over to Damon, just a couple of further slides. The first one is just to pick up on a couple of other interesting things I found from reading the new bill. One of which is that the bill imposes liabilities for individuals as well as the travel companies themselves. So the new rules will allow the CMA to impose the sorts of infringement notices that I've just talked about, including the ability to impose fines on directors, managers, secretaries, or other people who control the business if those individuals have either consented or connived in the breach of consumer law. So that seems to me to be potentially quite significant for individuals within the company to ensure that the company itself is complying with consumer law. Otherwise, they themselves potentially in the firing line under this new fines regime. And the other thing which is worth noting as well is the existing enforcement mechanism is still going to be there. So the CMA, the CAA, and trading standards will still be able to take travel companies to court in order to get enforcement notices, as they currently do. But the new bill introduces powers for those regulators through the court procedure to also impose fines of the sort that I've been talking about today for non-compliance with consumer law and failure to comply with undertakings previously given. So obviously in our sector, I'd say the CAA is probably the most active outside of the CMA. So we could see a situation in the future where the CAA decides to take a travel company to court for non-compliance with the package travel regulations, and then in addition to seeking an order to force that travel company to comply with the package travel regulations, they could also seek a fine up to 10% of turnover for the previous breaches by that travel company. So quite significant changes there, I would suggest. Next slide, please, Eva. Now this I just thought worth flagging what the CEO of the regulator has been saying about these new powers, and to the question about whether they'd actually be complied with in practice, and whether they have the resources to actually use these new enforcement mechanisms, because that's often the problem with new enforcement powers, is whether the regulators actually have the funds and have the budgets and have the resources to enforce. And I just want to pick out one part of her answer to this question, where she said that they currently have a legal directorate of around 150 people, but they're looking to grow that resource by more than 200 people over the next 2 years. So they're obviously recruiting in order to get the resources needed to enforce these new laws. Next slide, please. So I won't go through this now, and I'll hand over to Damon. But obviously, some of you may be thinking, well, what should we be doing to reduce the risk of being caught up in this new enforcement regime? And I'd suggest that there's probably, five pillars. There's 5 things that travel companies need to look at, which these new laws are looking to cover: marketing practices, sales techniques, terms and conditions, compliance with the package travel regulations, and compliance with your general obligations to treat customers fairly. So now is probably the time to audit your compliance with these various laws and to make sure that you're not falling foul and potentially coming onto the radar of the regulators. Next slide, please. So that's it from me. And on that note, I'll just hand over to Damon.
Thank you, Louise. I think there was an awful lot in there, and certainly a lot to be considered. So no, thank you, and thank you for the opportunity to just provide a bit of a quick update as much as possible of some of the changes that are going on at EU level. And while we say all these changes are going on at EU level, they will and they do directly impact UK businesses, where those UK businesses are effectively selling in to the EU market. So where the goods they're selling go into the EU market, or where the services that are being sold are being consumed in the EU market. One of the main sort of proposals coming out at the moment, which is getting a lot of publicity, is VAT in the digital age, otherwise known as VEDA for the platform economy. I will come on to that in a bit, because there are some significant changes in there. But before I do that, I wanted to have a look at something that's actually already in place, some changes that have already come into place. Next slide, please. So these changes around the reporting obligations for online intermediaries that facilitate the B2C, so that's consumer, sale of goods or services. So the online intermediary doesn't necessarily needs to be acting on behalf of somebody else. So a hotel owner, excursion company, attractions, anything like that, where the intermediary is allowing a consumer to book through them this other service, or to buy goods. These are very connected to the OECD changes and the EU, what they call DAC 7 legislation that came in with effect from the 1st of January 2023. That requires online businesses to maintain a whole lot of data and to provide reports on those data to relevant different authorities. This particular rule is actually a subsection of that, which is the EU implementing in the tax legislation, the VAT legislation, requirement for online intermediaries to provide reports of the sales they make on behalf of third parties, commencing with effect from the 1st of January 2023. That's when the law was effective. The first reports are due to be submitted from the 1st of January 2024. At the moment, though, only where these are requested by the tax authorities. So effectively, a business can sit there, not necessarily need to do anything, and then at the point in which they're requested by the tax authority to provide the details, then there'll be a time limit for delivering that report in, and potential fines and penalties for failing to actually then provide the reports, if that's what happens. So I think that's something that's actually already in place. I think that's gone under the radar a little bit. And so I think any online business is effectively acting as an intermediary in the sale of any travel services that are going to be consumed in the EU probably should be aware of this now and should be thinking about how you collate the data on the sales you're making on behalf of the third parties. But as part of the VEDA, so the VAT in the digital age for the platform economy proposals, which I'll come on to in a minute, part of those proposals are to extend this reporting requirement. And the extension is going to make the reporting mandatory and standardized across the whole of the EU. So effectively, the businesses will automatically have to start filing the reports. Now, it's not clear when that's going to come in. I think the proposed date is in line with the rest of the changes for the platform economy, which is the 1st of January 2025, although that may well be delayed, as we'll come on to in a minute. But don't be at all surprised if the changes to the reporting requirements are implemented earlier than the other broader changes that we're going to talk about. And the combined impact of the VEDA changes and this reporting, I think, could mean more VAT in the supply chain. So how does that work? Well, let's have a look. Next slide, please. This is the perception, I think, of kind of where the EU sees what's happening at the moment in terms of the VAT accounting. So you'll have the supplier, hotel owner, attraction owner, whoever it is, may apply a net rate into the intermediary and will probably be accounting, or the perception is that they'll be accounting for VAT on that net rate. However, the intermediary may then make that that service, that hotel accommodation, available to, say, a tour operator for booking at a higher price, because that will include the intermediaries' marketing fee, commission, whatever it is they call it, technology fee. I've seen it called all sorts of things. But because the intermediary is often then in a different country to the service provider, they don't necessarily apply VAT. Under the current rules, quite rightly, they wouldn't necessarily apply VAT to their commission. Now, that just means that ultimately the consumer may end up paying an amount. Some VAT may be due under the tour operator's margin scheme from the tour operator on some of that, but there'll be a proportion, or the perception is there's a proportion of what they pay that is not then taxed. Next slide, please. Same sort of thing if that's direct to consumer. So, for instance, an OTA, again, whether this is exactly what's happening is debatable, but this is certainly the perception at EU Commission level as to what's happening. And it's probably a little bit of a clearer example here, where the end consumer pays £300 to the OTA. The OTA retains its marketing fee, 40, on which there's no VAT, but the travel service provider may only be accounting for VAT on the net rate of 260. Just for ease, all of these amounts are all assumed to be including VAT, because otherwise it gets a bit complicated. So yeah, next slide, please. So this is what they're looking to actually get to, and what they're looking to achieve. This is what already exists now, as we say, for the reports that should be submitted for the 2023 year of request, but going forward will be mandatory. And the whole idea, I think, is that the intermediary will actually report to the tax authorities that they've collected the amount they've collected on behalf of the third-party service provider. So they will report to the tax authority that they collected 300 on their behalf, that they charge a commission fee or admin fee or technology fee within that, but that will allow the tax authority to actually then go to the service provider and say, well, the actual value of your sale through the intermediary was 300, therefore we want VAT on that 300. That, on the whole, could, as you say, increase the level of VAT there, reduce the net take for the service provider, who may well then look to pass that extra cost through the supply chain, which is how you end up with potentially increased VAT, ultimately impacting in higher end prices, but we'll see. So that's the aim of these, what the EU Commission is trying to achieve in terms of trying to implement this reporting requirement. And all of the EU member states at the last EU finance meeting were absolutely fully supportive of this type of reporting requirement. So it will come in, and they will extend it. So next slide, please. But what's actually also the proposals going forward, which I think is quite a big one. There's lots of complexity to this, but effectively they're looking at the online marketplace for the sale of short-term accommodation and for passenger transport. We'll come on to some of the questions that are still open on this in a bit. But effectively, this is trying to capture the likes of Uber, Airbnb, Vrbo, but the way in which the changes are coming in, it will effectively potentially impact on any technology marketing supplier intermediary that's facilitating the sale of certain types of accommodation and transport on behalf of third parties. At the moment, the reason there's a problem is that there's a complete inconsistent application of the way in which VAT applies to this type of accommodation and transport. I think we may have all seen the reports of the Italian tax authorities challenging Booking.com, the UK authorities challenging Uber, and so on. Well, that's exactly what they think the problem is. And that the way in which the VAT legislation is structured at the moment, it doesn't look as if there's any VAT being collected. There's sort of technical things for that, the reasons for that, but small business exemptions, VAT registration thresholds, inconsistent law, whatever. But perhaps if we look at the next slide. Thank you. So this is what they think the current position actually is at the moment, and therefore what the challenge is. They're looking at the property owners, drivers, on the businesses where, for one reason or another, there's every reason to think that no VAT is being collected on this. And then the intermediary platform potentially works the very same way as it does for the other travel services we were looking at. But in the end, we're getting to a situation where the consumer is paying an amount for this service, and potentially no VAT is being collected. And under the EU system, that's inconsistent with the way in which the law should work, as it's seen. Next slide, please. So I won't go through these in detail, but these will come out to you. But these are the proposed changes, the changes to the main EU VAT directive. Next slide, please. There's also changes to what we call the implementation regulations. This is where most of the detail will be found in terms of explaining how the law will actually apply. But next slide, please. But what? Oh, sorry. So yes. So what is it going to do? So I think, I'm not sure whether we've skipped a couple of slides, but no problem. The ultimate impact of it is to implement what is called a deemed supplier rule. So the intermediary will become a deemed supplier for the supply of the short-term accommodation or the passenger transport. At the moment, there's no definition of exactly what a platform is, but we expect that to come in. But it will apply where the platform definitely acts as the intermediary and allows the consumer to book and takes payment, but where the intermediary is not the principal in that supply. The platform will then be responsible for the collection and the remittance of the VAT to the tax authorities on behalf of the underlying suppliers. But they will be seen as the party liable to collect and pay that VAT across. And the payment is likely to be, if anyone's ever come across it, through what is called the one-stop shop. But that's a technical way in which one business, effectively a UK business that might end up having to pay VAT across to 20 or different member states, will pay it through a central system where they'll pay the VAT that's due in each individual country at the applicable VAT rate. Next slide, please. The platform, if they are a deemed supplier, these suppliers will be excluded from the tour operator's margin scheme. So they won't be able to just calculate the VAT on the margin. It will be on the full consideration. However, how that works at the moment in terms of, well, what happens if the platform actually then does decide to take principal status, so be in the tour operator's margin scheme, that's not clear, and we're waiting for further confirmation of that. There will be changes to the individual EU country laws as well. For instance, Denmark has an exemption, so an automatic exemption for the supply of all what they call summer houses. That's likely to have to go. And the whole reason, if you think when you're looking at it, is the Commission believes that the changes could capture up to 6 billion additional VAT every year. That's why they're looking at it, and that's the hole they think that exists in the VAT system at the moment. Next slide, please. So yeah, so this is what it would look like if you think about it, and this is what they're trying to get to, is again, you get to the fact that the property owners will probably still be exempt from VAT, will not be accounting for VAT, but won't be able to reclaim any VAT. And the deemed supplier will then be required to account for the VAT to the tax authorities on the full money they collect from the end consumer. So in this example, the whole 300. So whereas at the moment you've potentially got no VAT being paid on that, there could be VAT on the whole amount. So how that will actually then impact on the prices will need to be seen. You know, how much will the industry swallow the cost, or how much will they seek to pass on to the consumer? I mean, that's generally market driven, but it's likely to mean increased prices. Next slide, please. Same thing on a more complex supply chain. The key issue here is always the first intermediary in any supply chain that is then going to be what is called the deemed supplier. And again, always remember that's where that intermediary is acting as what we will call an agent, a technology provider, is not acting as a principal for the supply of the underlying supply itself. Yeah, next slide, please. There's lots still to be discussed. The EU wanted to implement this with effect from the 1st of January 2025. There was a meeting of the EU finance ministers earlier this month. They raised an awful lot of questions, so it's likely the changes will be delayed. But how long they'll be delayed for, we don't know yet. But it wouldn't surprise me if the full changes don't actually come in until 1st of January 2026. But we watch this space, I think, is how that goes. Next slide. Please. But yeah, I think the other thing I just wanted to touch briefly on, because we're a bit short of time now, is at the same time as all of this going on, the EU is undertaking a wide-ranging review of the way in which the tour operators margin scheme itself works. The idea is that the EU will agree new proposals for a new tour operators margin scheme sometime around the end of this year, beginning of next. Likely implementation date, probably again around about 1st of January 2026. So that could be a big year for the industry in terms of all of these changes. Next slide, please. I just put on a summary there of what I think the key conclusions will be, because they're looking at a complete review. I think the way it will work is that the tour operators margin scheme will be optional for B2B suppliers, as it is in the UK at the moment, but whereas it's compulsory in the EU that it applies. The tax, importantly, will be due where the traveller is resident. That's very much where it's consumed. That's in line with all of the recent big VAT changes that introduce VAT by reference to where the service is actually being consumed, which is typically where the customer is. It will provide, I think, for a clear definition of what is and what isn't in the margin scheme when it does apply, whether it's for single services or packages, etc. We'll get clarity on that. How the VAT will be calculated is likely to be through a number of different methods. And what would it mean for UK tour operators? It probably means, if those changes come in that way, no change now if it's a UK tour operator selling to a UK consumer. The margin scheme should still apply, but the margin will then be zero rated under current UK law, unless UK law changes. But if you have a UK tour operator selling EU travel to an EU consumer, then they're likely to have to pay VAT by reference to where in the country where the consumer resides. And again, that's by way of what is called this one-stop shop. So that was a really quick rattle through. I think we'll try and cover off as many questions as we can now. But my contact details are going to be available if anybody has got any questions. Happy to have meetings, discussions with anyone impacted by these changes to understand it a bit better. Thanks.
Thanks, Damon. That all sounds quite significant. So we've got some questions. Perhaps I'll answer a couple of the ones directed to me, whilst Damon, you have a look at the couple of questions on tax reforms. So the first question is, how will the CMA go about enforcement? Will there be a warning first with a reasonable time to discuss, adjust, etc.? Well, I think the working practice seems to be when the CMA sees conduct in a particular sector it doesn't like, it starts with some sort of open letter or some sort of campaign targeting that particular sector. We obviously saw this during the pandemic, where the CMA sent 2 open letters to the travel sector dealing with certain areas of non-compliance. And we've actually seen this more recently as well, where there's been a more general letter to companies in relation to kind of online sales techniques. So it'll set out the things it sees, the things it doesn't like, give an opportunity for people to get into compliance. That then is usually followed by targeted action against particular companies. Tends to be the larger ones, I have to say, where they seek to make an example of perhaps some of the bigger companies and then use that enforcement action to get other people to fall into compliance. And what you usually see is it starts off with a process where there's an initial letter asking you to confirm contact details and things like that, and then they serve the information notice, which then leads on to the full enforcement process. So that's the way that it usually goes. And I think, you know, once the CMA starts enforcement action against a particular against a particular company, they tend not to stop until they get binding undertakings or something more formal than that. So I'm conscious that we've just run over the 10 o'clock deadline. Damon, I don't know if you want to pick up on one of the
Yeah,
tax questions.
yeah, I've typed an answer, so hopefully they'll come through to the people that asked it. But in the main, the question was, well, how are we going to define where the tax is payable? For the deemed supplier rules for the platform economy, the legislation is geared to collect the tax where the travel service itself is consumed, so where the hotel is, where the transport takes place, etc., irrespective of where the customer is. So if the hotel is in Germany, expect to pay German tax, that sort of thing. The other one was a question around, well, how do we, if we're going to tax by where the consumer is resident, how do we know that? And again, the way the current law works is it looks at where the payment, how you connect it to where the payment is, so where the consumer's bank account is, where the credit card is registered. It'll look at 2 or 3 pieces of information and evidence that the business should collect about where their consumer is and how they're paid to then determine where that tax is due. So those are the typical ones.
Thanks, Damon. So I think what we'll do, because we've run out of time, we do have the questions and we have the email addresses of the people who asked the questions. So we'll follow up with quick answers to those questions. But I think for the purposes of this session, we'll draw a line under it. So can I thank Damon for joining and taking us through those EU tax reforms? I can also thank everyone else for joining as well this morning. So thanks very much.